Good morning. We're going to get started. My name is Eileen Cotto, a judge in the other Washington in Seattle, and I'm very proud to serve as a member of the Board of Directors for Justice at Stake and currently serve as Vice Chair of the Board. I do want to send the regrets of our Chair, Mark Harrison, who has perfect attendance at all of these summits and meetings before the summit got started last year, but due to family commitments, he was not able to be here. He did send us an email yesterday, all capital letters with exclamation points all over it, that said that I hope it's a great success, and I'm very sorry that I cannot be there with you for the summit. So it comes upon me, my great pleasure, to welcome all of you to the Justice at Stake Second Annual Fair Court State Summit. This is entitled Allies, Advocacy, and Action. The Fair Courts State Summit is, I have to tell you, an event like no other. And I look forward to all the opportunities that we'll all have over the next 2 days to learn and to be inspired what we'll share over the next 2 days. I do want to extend my personal thanks to all of you for attending and joining us as guests this week and your commitment to the cause of fair courts. So it's also an honor and a pleasure for me to be here as well. To begin, I would like to welcome to the podium my very dear friend, Justice at Stake's Executive Director, Bert Brandenburg.
Judge Cotto, thank you. Good morning, everybody. Good morning, everybody. You are a special group. You are the only people in the United States who have not declared for the presidential nomination. So you are the swing voters. Congratulations. Welcome, as Judge Cotto said, to Justice at Stake's second Fair Courts State Summit. It is energizing to be in this room. Those of you who have been with us for a while know that this event and the one the year before are the heirs to what used to be twice-a-year meetings. We have more people than we had last year. This is the biggest event Justice at Stake has ever had. We're very excited you're here. We have a great mix of old friends and new friends. And we're all here because we know that democracy can only be strong if our courts can be fair. And we have a terrific 2 days ahead of us. I want to start by thanking our wonderful sponsors, our summit leaders, Appleseed, the Piper Fund, and the Wellstone Action Fund, our summit partners, the American Constitution Society, the Brennan Center for Justice, and the Committee for Economic Development, and our summit friends, Every Action, Lambda Legal, and the National Coalition to Abolish the Death Penalty. We thank you so much. Your partnership is indispensable. Your support for this event was critical to making it work and making it be our biggest and best ever. I also want to acknowledge there are a number of members of our hardworking Justice at Stake board who are here, in addition to Judge Cotto. They'll either be here right now or over the next couple days. Bob Peck, who will be on a panel here in a minute, Mike Petro, Jamie Barnett, and Ricky Seidman. And a special welcome to all of you, advocates and allies from more than 31 states from around the country. We gather here as defenders of democracy. We are stewards of a promise that the Constitution makes that justice will be equal and impartial, and we all are here because we know that that can only happen if courts are strong and fair themselves. That's the only way the promise is kept. We also know that our courts can't be fair if they're on call to super PACs and talk show hosts and party bosses. And we know that fair courts matter to everyone, to consumers, to workers who need a level playing field, to businesses who need stable rules to help create jobs, to the accused whose very lives depend on equal justice, to an asthmatic child who needs clean air to live a good life, to everyone in this community and all of us around the country who depend on the law, I should say, to uphold their rights, and to everybody here who certainly knows, and everyone around the country who knows that fair elections require fair courts. We are gathering at what I think is a crossroads moment for the fair courts movement. Judicial elections are broken. No way around it. Campaign cash is poisoning equal justice. 3 more states set new records last year. 8 states smashed the $1 million mark. This is the new normal. The wealthy players are signaling that they're in it for the long haul, and they're going to throw dark money in if they have to buy up the courts. State lawmakers are growing more brazen. They want to bully judges who don't toe the line. So just last week in Oklahoma, after their state Supreme Court ruled 7-2 that a Ten Commandments plaque that had been erected a couple of years before must be removed from state grounds, a group of lawmakers promised to impeach all 7 justices. In the majority, a committee chair then began talking about reducing the size of the court, cutting the budget in half. This is the new normal. The 2016 presidential campaign is already underway, and it's already affecting what's going on around the courts. Supreme Court nominations and nominees, there's talk of litmus tests. Supreme Court justices, under the proposal of one candidate, should have to go out on the campaign trail to keep their jobs, to woo interest groups and super PACs in a retention election. Most ominously of all, there's fresh data and scholarship, even since last year, that shows that campaign cash is affecting courtroom decisions. In other words, we have reached a moment of grave risk when it comes to that promise the Constitution makes about fairness and impartiality, and that promise is very close to being broken, and a lot of people think it already is being broken. But thanks to a lot of hard work, we also have successes to celebrate. In Williams-Yulee versus the Florida Bar, the Supreme Court of the United States affirmed that campaign politics have no place in the courtroom. In Kansas, a number of the terrific advocates who are here today, and a lot of you around the country working with them, fought off efforts to once again try to eliminate merit selection for the state's Supreme Court. And in Tennessee, a bullet was dodged. In the face of efforts to move that state to pure contested elections, voters instead approved a system that allows critical components of a merit selection system to function. We are making progress recruiting new allies from a wide variety of advocacy areas, and we welcome especially those of you who are with us for the first time. We're very excited you are here. This is the mode we need to be in to succeed, to be growing. And in addition, I believe our years of collective work raising awareness around the issue are paying off. More policy leaders are learning about the threat. Opinion surveys show that record numbers of people are getting the connection between cash and the courts. And when John Oliver does a 13.5-minute segment on judicial elections, and when he says, quote, "We should tweak the blindfolded lady holding scales to put a tip jar in her hand and give her an," and here I will delete an expletive, "winking emoji for a face," our years of work together are finally on the cusp of a breakthrough into the mainstream, into pop culture, and into growing awareness, the awareness that we need to then win victories. We are growing stronger. Our coalition is bigger. It's broader. It's more diverse than it's ever been, and we know that with the right resources and the right strategy and focus, we can win. That's why I'm so excited about the summit that we put together. Today's program will be terrific. We will have plenary sessions about what's happening in the world of fair courts, who's trying to buy influence, and how to build our communication skills. We will hear the first of 2 keynote addresses today from Sue Bell Cobb, tomorrow from Wallace Jefferson, both former Supreme Court Chief Justices, one Democrat, one Republican. They will be breaking the silence about what judicial elections are doing to the courts. In small group sessions, you will hear about new research. You will learn how to build networks, how to make headways in state houses, how to explore hidden biases that are hampering efforts to diversify the judiciary. And tomorrow, I hope you'll stay with us, we will have a very special presentation on how the courts failed Germany at the very moment before all was lost to the Nazis, when the rule of law there stood on a knife's edge. And we will have lots of time throughout to network and make new friends. We have more attendees than ever, but for those of you who were with us last year, you know we had a slightly larger room. We actually brought it in a little bit in order to make things more intimate. We want to take advantage of that. And I want to thank as well the 2015 Summit Steering Committee for putting together an outstanding program. Adriana Barbosa and Karen Shiwi from Wellstone Action, Alicia Bannon from the Brennan Center, Kathy Bonifield from the Piper Fund, David Lyle from ACS, and Mike Petro from the Committee for Economic Development. I also want to thank the excessively talented Justice at Stake staff who helped organize this event, and I'm just going to ask that the staff raise their hands so people will know who they are as I mention their names. We have some new faces since last year. Scott Graytak, our Policy Counsel and Research Analyst, Joy Jankuyak, our Development Manager, Genevieve Whitaker, our Executive Assistant and Project Manager. Also with us are Deborah Ehrenberg, our Director of State Affairs, Peter Harden, our Senior Writer, Lori Kinney, our Director of Communications, Barry Novich, our Operations Manager, Liz Seaton, our Deputy Executive Director, Peter Starzinski, our Senior Organizer, whose first day on the job was at last year's summit. We have some outstanding interns with us this year, Emily Carter, Tanisha Mitchell, Cecilia Yanez. We also have law clerks, Kelsey Powderly and Michael Sanchez. I have left out one name until now, and that is Elisa Ortiz. Elisa is new to us as well. She's our new Deputy Director of State Affairs. She is also our State Summit Planner-in-Chief. She has done a phenomenal job. This is our biggest and best event yet, and I hope you'll join me in thanking her. So a couple of housekeeping notes. This event is open to the press. You are welcome to tweet and use other social media. Therefore, consider this on the record at all times, on stage, in your seats, in the hallways. You're all welcome to join us for a reception and dinner at Bistro, which is not far away, immediately following the event. Maybe we'll have a no tweeting after the second drink rule. We can figure that out. If you have other questions about anything, we have a registration desk that we permanently staffed. There are staff members everywhere, so please let us know if we can help you with anything at all. And finally, I do want to acknowledge that this is a meaningful moment for me. After 14 years, I will be departing next month to become the new president of the organization Appleseed. This is my, therefore, last event with Justice at Stake. It is a little bit odd and very stimulating to be looking back on the year 2000, when Justice at Stake was founded. And if you think about the year 2000, most of you probably spent a lot of your years looking forward to 2000, thinking, what will it be like then? Now we're actually looking back at it. But in 2000, the money explosion was just beginning in the courts. Judicial elections at that point were getting about as much attention as city council meetings. In the year 2000, there were only 4 Harry Potter books. In the year 2000, cell phones were just overtaking pagers in popularity. And in the year 2000, the phrase hashtag probably would have been considered an illicit playground game. And to be there then, in those early days, there was just such a sense of adventure to design the stationery and recruit the first partners and to really sort of start standing up something that was brand new in American politics. And now, 14 years later, what I marvel at is this room, all of you, people who are carrying it forward, and really what we've become and what we've done together. And as you carry this work forward, please know that you stand on the shoulders of some amazing people. John Cowell and Malia Reddick and Lynn Marks and Catherine Terser are here in this room, and they were in those first rooms. We have lost a few along the way, like Larry Hansen and Tom Moyer and Sandra Otaka. But across the country, there are many others, people like Jerry Palast and Jim Wynn and Tom Phillips and Roger Warren and Cindy Canary and Rich Robinson and many more who did band together a decade and a half ago to help build something new because they loved democracy enough to stand up for it. And they knew that for a constitution to keep its promises, there have to be guardians. You are their heirs. You are the guardians. You have a busy 2 days ahead of you. So saying farewell is bittersweet. I will miss so many people. I will miss this work that I love, but I have to say I'm feeling a very sort of deep happiness sort of at this very moment of what this room is and who you are and what we're doing and what it is to be with this newer and bigger generation of fair courts advocates that's going to carry the work forward. I am proud to depart a Justice at Stake that is bigger and stronger than it has ever been, with a super talented staff. And while we conduct a search for a new executive director, we are extremely fortunate to have Liz Seaton serve with us as our interim executive director. So as all of you prepare to do things that we could only dream of 14 years ago, on behalf of all of us who worked so hard to build a fair courts movement, here are the keys. Go win the race, And I'll just finish by saying #thank you. Thank you so much. Now let's roll up our sleeves. I'm pleased to turn our first program over to Bob Peck, who is president of the Center for Constitutional Litigation and a member of the Justice at Stake Board of Directors.
Good morning. As our panelists make their way to their seats, let me add my welcome to that of Eileen and Bert. For those of you who've come to Washington from out of town, we're very proud in Washington to say that we're number one. Of course, the category is sleep deprivation. But we have a great panel to start you off today and to talk about the Williams-Yulee case and a victory at the Supreme Court. Now, our panelists, as I said, are fantastic choices for this discussion. Your materials and the website provide fuller biographies on them, but let me just quickly introduce them. We have Justice Peggy Quince from the Florida Supreme Court, Matt Menendez from the Brennan Center, and Justice at Stake was very proud to partner with the Brennan Center on the good government amicus brief filed in the Williams-Yulee case, which was cited by the court several times. And Suzanne Diaz, a lawyer from Arizona who is the immediate past president of the Arizona Minority Bar Association. Now, I know that there was a burning question not answered in their biographies about each of these, and so because I anticipated that, I did extensive research on each of our panelists, even though two of them are longtime friends. But I can assure you that none of them have been accused of jiggery-pokery. Although one of them wishes he had. In any event, the Williams-Yulee case, of course, caused great trepidation in our community when the Supreme Court took it. The two previous cases that dealt with judicial elections in some degree had been decided 5-4. The first of those cases, Republican Party versus White, of course, showed a libertarian free speech streak at the Supreme Court that is consistent with all the campaign finance decisions that they had been rendering. And so as a result, they struck down the ethical obligation of judicial candidates not to take positions on issues. So that precedent, of course, loomed large when the court took Williams-Yulee. Then, of course, we had the Caperton decision, and that at least gave some balance to it, again 5-4, but demonstrated that at least in some instances where there is a great potential for actual bias, there would be a due process requirement of recusal. And so, not sure how this case would really come out. We of course, organized to respond to it. And of course, here again, we had a 5-4 decision. And the interesting thing is that Justices Kennedy and Chief Justice Roberts switched positions from the Caperton decision. And that's what gave us our 5-4 decision. So rather than give you more background myself, let's turn it over to our panelists. Peggy Quince, as I said, is from the Florida Supreme Court. It is the Florida rule that was before the court, and she can give us some background on the case.
Okay. Good morning. It's a real pleasure to be here and really to talk about the Williams-Yulee case because we in Florida we're very, very interested in our canon, which basically says that judges cannot personally solicit money. That if you are in an election campaign, that you have to have a committee of responsible persons who would raise money for you. And that is applicable whether you are a sitting judge or a candidate for judgeship. And I must tell you that this is so important to us because it goes back to the 70s when we had on the Florida Supreme Court nothing less than a corruption scandal. In the 70s, in the early 70s, all judges in the state of Florida were elected. Trial court judges, appellate court judges, and the Supreme Court justices. In the early 70s, 44 of the 7 justices were accused in some ways of corruption. There had been memos given to justices by parties in various cases. One justice had gone off on a gambling junket with campaign contributors. Others had, tried to fix cases in the lower courts, and so it was a big mess. 3 of the justices resigned before impeachment proceedings could get started, and one of them actually was a fugitive from justice at the time that he died. So there was a lot going on. And so our governor at the time, Ruben Askew, really got together with legislators and other people who were stakeholders in the justice system and decided to have a reform. And that's when we went to the merit selection and retention of appellate court judges and the Supreme Court justices. However, our trial court judges, both at the circuit court level and the county court level, are still elected. We had referendums in various counties that were put on the ballot to determine if those counties wanted to go to the merit selection and retention process for the circuit court and county court judges, but it did not pass in any county that had it on their ballot. And so we still have election of trial court judges. Now, I must say that in most instances, there are very few judges who are up for election because I assume it's the case in most states. Once they become judges, generally they don't get opposition, and so when it's time for re-election, there's no opposition, and so you're automatically re-elected. But for those who do have opposition, or when there is a vacancy and many people are applying for it, you go through the regular election process and money is raised. I know this because I went through it myself in 2012 on a retention election. Never in the state of Florida, since the 70s when retention elections began, have there ever been any true opposition. Now, in the late 80s, early 90s, there had been some movement and a couple of justices had gone around the state, but there was no real money put into those retention elections. Fast forward to 2010 was the first time we saw, and this was of course the same year that we had the defeat of the justices in Iowa. Well, there was a smaller movement in the state of Florida, which really was more of just a social media campaign against 2 of the 4 justices that were up for retention. And quite frankly, those 2 justices received smaller numbers of retention than the 2 that had not been targeted. So the 3 of us who knew we were up for retention 2 years later decided that should those kinds of things start happening, we would do something about it. And sure enough, not a month after the election, a group came out saying they were going to go after the 3 justices that would be up in 2012. And so we started. We got our committee of responsible persons together, and we actually, between the 3 of us, raised over $1 million. Never before had anything like that in Florida happened. And money was put into opposition. We had a group called, let's see, what was the name? Restore Justice and Americans for Prosperity. and they put money into a campaign against us. And so we felt we had to do something. We were not going to be like the people in Iowa. So, but it was very important to us that we not go to the very people who appear before us and ask for money on a face-to-face level. Who's going to say no? I think that is very intimidating, and that's why our rule to us is so important. We don't want lawyers, basically, and other people to feel intimidated because they know that at some point their case is going to come before us. And we don't want judges to feel that they must recuse themselves because people are contributing to their campaign. And quite frankly, between our canon that says you cannot personally solicit, and at that time, the limit that anyone, whether it was a person or a corporation, could give was $500. We had a ruling that was de minimis and would not be cause for recusal. So between those two items, we felt that judges were pretty safe in their campaigning. But then we get to the Williams-Yulee case, and we have a person who is not a judge, but a candidate for a judgeship, who decides to send out personal letters and emails soliciting campaign contributions. And once the campaign was over, our judicial the candidate did not win, but still, the Judicial Qualifications Commission looked into those campaign activities, and of course the case eventually came to us about the violation of Canon 7C1, which is the canon that says you cannot personally solicit. And the rest, as they say, is history. And we were so proud and happy that we had other partners, like Justice at Stake, that was interested in this issue, and I did amicus briefs. And I believe it is important for all of us, all over the United States, to really pay attention to what is going on in these judicial elections. We truly are the place where people come to have a fair and impartial determination of their disputes. And if that is no longer the case, then our democracy has fallen. We need to make sure that every person, rich or poor, black or white, gay or straight, whatever it is, come before the court and know that they have a fair opportunity to present their case, no matter who the opposition is. And that's the problem you face when you have people putting money into judicial campaigns. How am I going to feel if someone on the other side has contributed $1 million to the justices or the judges' campaign? Am I truly going to get a fair determination? And whether the judge really, in all truth and honesty, feels that he or she can be fair, it really comes down to the appearance of whether that judge or that justice can be fair. And so I believe that this is one of the most important decisions that the judiciary has had to face in a number of years. And it may be a 5-4 decision, but we'll take it. Because it's just so important. It is, to me, the ban on personally soliciting really is a shield between the judges and justices and all those who do, in fact, contribute to their campaigns. Now, one of the things that is often said is, well, you can see who gave to your campaign anyway. And that is true, because in the final analysis, the campaign is your campaign. And you've got to make sure that everything that is done according to all of the canons, all of the laws that are applicable to campaigning. And you can, in fact, see a list of your contributors. But quite frankly, I never looked at it. You know, I looked at the bottom line of how much was actually collected. I looked at how the monies that were collected were expended to make sure that they were expended according to all the campaign laws. But I really was not interested in who the actual donors were. I was interested in the people really did make donations. But I never looked at that. And then that's not to say that you can't. But I don't think that just looking at a campaign list and seeing who actually made contributions really makes any significant difference, especially when you're talking about I believe, de minimis amount that people really can contribute to our campaigns. Although the legislature, I must say, has changed it, and I believe that the maximum contribution now is a couple of $1,000s. But, and we haven't had any opportunity, of course, no one has brought that to us as to whether or not that amount would require recusal or not. But I'm going to leave it at that so we can hear from other people and you'll have an opportunity to ask questions. But I thank all of you who are interested in fair and impartial courts for being here and helping us to try to maintain what I consider to be the branch of government that truly is there for the people.
So let me turn it over now to Matt Menendez. Matt was probably the person most responsible for crafting the amicus strategy that resulted in that overwhelming win in the Supreme Court, the landslide vote. So let me turn it over to you, Matt, and why don't you take up the story?
Okay, so I think it's interesting. After the decision, I talked to quite a few people who expressed surprise. Apparently, my guarded optimism about this case was sort of out in left field. But I thought we had a really good chance to get the chief. I was quite wrong about the chance to get Kennedy, apparently. But the reason I thought we could get the chief is, while I disagree with him on most jurisprudential matters, he's not only the Chief Justice of the US Supreme Court, he's the Chief Justice of the United States. And I think that he takes that responsibility very seriously as the ultimate steward of the reputation of America's judiciary. And I think it's important to remember that the vast majority of judges in the US are state court judges, and the vast majority of judges in the US do face election. And I think one of the interesting things about this opinion, remember, this did not come to the court as tabula rasa. There were a number of federal courts where this had reached the appellate level, and a number of state Supreme Courts, including Florida, had considered this. And I think it's interesting that at the appellate court federal level, where Article III judges have life tenure, the majority of courts had struck this down as violating the First Amendment. On the other hand, at the state Supreme Court level, where most of the judges were elected, every state Supreme Court had upheld this rule. And I think that reflects an understanding of the reality of running in these campaigns. Mm-hmm. And I thought that the majority opinion was much more pragmatic than most of the federal opinions had been, and reflected the reality of fundraising. And part of this was, and I think this was one of the reasons our amicus strategy was effective, we put in front of the court the realities of judicial fundraising, where the vast majority of campaign contributors are lawyers, frequent litigants, and special interests whose interests come before the courts. And I think that is particularly important. We also did polling. When we were putting together the Good Government brief, we thought, oh, well, let's show them what the public actually thinks about personal solicitation. And it turns out nobody knew. So we, at the Brennan Center, got together with Justice at Stake, and we asked a lot of people in states where they have elected judiciaries, what do you think about judges personally asking for campaign contributions? And the results were very interesting. So we were pleasantly surprised in terms of putting together an effective brief by these numbers, that 63% of the respondents said that personal solicitation would lower their confidence in the courts. Strikingly, of that group, 81% said that it would lower their confidence in the courts a great deal. And I think this was really reflected in the majority opinion, and even more so in Justice Ginsburg's concurrence. This case, unlike Caperton, didn't really center on an actual due process threat. It was much more focused on the public's confidence in the courts, which is absolutely critical. And there's case law going back saying that justice must satisfy the appearance of justice, and to reaffirm this interest. And so the public's confidence was folded into the main concept of the majority, which was judicial integrity. And I think the recognition of the threat to judicial integrity that personal solicitation poses was really notable. And in doing so, the court, in some very good language that I think everybody in this room should like a lot, truly drilled down to the difference between judges and politicians. And if you'll indulge me, one quote from Justice Roberts. He said, "Judges are not politicians, even when they come to the bench by the way of the ballot. And a state's decision to elect its judiciary does not compel it to treat judicial candidates like campaigners for political office." Now, going back to the Republican Party of White versus Minnesota case that Bob had mentioned, the majority in that case, while striking down the canon, had said, but of course nothing in this opinion requires states to treat judicial elections exactly like other elections. That's not very persuasive when it comes in the context of striking down a regulation that treats judicial elections differently than other elections. And I think it's also interesting that the justices in the majority really understood the point that Justice Quince made, that there's something uniquely coercive about a judge or justice personally asking for money. I was at the oral argument, and Justice Sotomayor put it very well. She said that as a judge, she has the opportunity to talk to lawyers all the time, and in all of her years as a judge, whenever she has asked a lawyer to do anything, how big or how small, a lawyer will bend over backwards and do anything possible to not say no. And when it comes to something like a campaign contribution, obviously lawyers have a particular concern with not aggravating a judge by saying no. And in reality, it's just easier to say no to a campaign committee than it is to a judge. And another good quote from the chief was, as he said, "The identity of the solicitor matters, as anyone who has encountered a Girl Scout selling cookies outside a grocery store can attest." So I think while this is absolutely unequivocal victory for the movement and a testament to the people in this room, and as Bert said, 15 years ago, this was such a fledgling issue, and now we are able to mount such a significant campaign, thanks in no small part to the great work that Bert has done over the years. That the victory is itself a narrow victory. This only dealt with one of the canons of judicial conduct. There are other ones, which we will hear more about in a moment, which are still under attack, and the Williams-Yulee case does not resolve the issue. And there is other very troubling conduct that is currently in legal limbo, I think. So while personal solicitation is very important, it's not a panacea. There are a lot of other issues we need to be concerned about. We absolutely need to worry about the flood of money into independent expenditures. We need to worry about dark money. We need better disclosure. We really need public financing for states that insist on maintaining contested elections. And then on the back end, I think we need improvement in recusal rules. I think most states after Caperton adopted a rather inchoate test that is not easily applied, and despite the fact that we continue to see incredibly expensive races, recusal remains a very rare beast indeed. And I think we need more effective, clear rules. We need soup to nuts efforts to protect the integrity of the judiciary going forward.
So despite the language that Matt mentioned from Republican Party versus White, the basic attitude of the majority there was if you are holding elections, then you're stuck with what elections mean. So that is part of what caused all the concern when Williams-Yulee went to the Supreme Court. And despite the fact that Justice Breyer likes to go around the country and says, on the Supreme Court, we're not junior league politicians, that idea had not really penetrated, and now we have language in a majority opinion that says so. But as Matt says, the issues continue to come. It's still not safe to go back into the water. And Suzanne, why don't you tell us part of the reason why?
Well, as this case was making its way through the courts, there's another case from Arizona that is kind of doing the same. In Arizona, we have kind of a mixed system. In counties where there are populations over 250,000, we have a merit selection system. In our smaller counties, which are the majority, we have election of our trial court judges. We had a candidate in one of those counties who lost an election in 2006 and then again in 2008, and he has brought a challenge in district court initially against 5 of those restrictions. And one of those was personal solicitation, and 4 others were what have been referred to as political activities restrictions. Specifically, it prohibited candidates for judicial election and sitting judges who are up for retention elections from making speeches on behalf of other candidates, not themselves, but on behalf of other candidates, making endorsements of other candidates, and raising funds on behalf of other candidates, and finally, actively participating in campaigns, other campaigns other than their own campaign. And that one is unique. That one is kind of treated a little bit separately than the first 3 political activities restrictions, because that one could possibly also prohibit a candidate or a judge from participating in campaigns relating to issues. So that one is going to probably, face the biggest hurdle, I think. It went to the Ninth Circuit, and those, by a 2-to-1 decision, those restrictions were found to be unconstitutional. The commission has requested and received en banc hearings, so that's where it is right now. It's sitting before the Ninth Circuit, and the Ninth Circuit has asked for and received supplementary briefs on the effect of the Williams-Yulee decision. The plaintiff, the appellant, has asked or has tried to distinguish the decision, even as it relates to the personal solicitations. So it's not completely dead, but I think that he has a really big hurdle, and I don't think that he's going to be successful. And maybe I'd like to hear from others if they think that differently. The interesting thing that the panel did was they said that these restrictions were unconstitutional as to non-judge judicial candidates only. So if it had gone forward the way they decided it, and if it does go forward that way, then you're going to have 2 different rules that apply. You're going to have one set of rules that allows for non-judge judicial candidates, that allows them to personally solicit or to make speeches on behalf of or participate in elections or endorse other candidates. And so I'm picturing this, especially in Mojave County, if any of you know, Kingman, Arizona, very, very rural area. And I'm picturing that they're going to most likely be involved in the local sheriff's election. And these are judges who are supposed to be impartial. So in every criminal case, you have the sheriffs on one side and you have the criminal defendant on the other. And regardless of your own political leanings, that's just definitely the appearance of bias. So on a civil side, I practice in civil court, and as a practitioner, it's made me first very grateful that I practice in Phoenix and in Tucson, where we have merit selection, so I don't really have to face this issue on a daily basis. But as Justice Quint said, you imagine having a judge come up to you and ask you as an attorney, oh, I'm running for election, or a candidate that's not a judge, I'm running for election, would you mind giving campaign contribution? In my mind, the first thing I'm thinking of is, if this person wins, I'm going to be appearing before this person, and they have directly asked me, I'm going to definitely be giving a campaign contribution, no matter what it takes. If you get a generic letter, then it's like, oh, this letter was sent to everybody, no big deal. You can just ignore it or make a contribution however you feel. But there's definitely the appearance, regardless of what happens. So.
Yeah. So the Wolfson case that Suzanne described, resulted in an initial decision that there is no level playing field between the candidate who is not holding office and the candidate who is. Sort of a bizarre way to approach things, considering the full panoply of constitutional protections that apply to elections. But the fact that the court could come up to that decision and now it being reconsidered en banc gives you a sense of how uncertain the law is here. So the first thing I want to say to the panel and ask is that, has Williams-Yulee given us any solid foundation to build on these next issues that we're facing?
Well, I think there are a number of issues that, of course, Williams-Yulee does not touch on at all. And quite frankly, we in Florida have a rule also that says that you cannot endorse other candidates. And we, in 2012, the three of us who were up for retention on the Supreme Court, actually were visited by our Judicial Ethics Advisory Committee because the three of us were campaigning together, basically. And they said that that was basically us endorsing each other. And so that we were violating, they said we were violating our own canon. So now fast forward to 2015 and we have actually revised our judicial canon and at least for retention elections so that judges and justices who are up for retention can in fact campaign together, especially in situations like we faced where there was a common opponent. It wasn't like one of us had an opponent and it was someone else for the others. We were all facing the same opponents. And so we said that in retention, the canon has been changed so that in retention elections, you can, in fact, campaign together. I mean, we've had Judicial Advisory Committee opinions that says you can't even ride in the same car together if you're campaigning. And so we have some work to do, really.
So are you allowed to sit at the same bench together during hearings?
And so after we had our visit from the advisory committee, we would go to the same events and appear at different times. How stupid is that? But that's what we did in order to satisfy the advisory committee. And so there are any number of issues that are still facing us in these both retention and regular elections that Yulee just scratches the surface, really.
Right. So Matt, are there building blocks that we can use in these next set of issues that are likely to come?
I think that there are. I'd like to highlight one other quote from Chief Justice Roberts, the majority. He said, "Simply put, Florida and most other states have concluded that the public may lack confidence in a judge's ability to administer justice without fear or favor if he comes to office by asking for favors." Now, if mutually campaigning for other political actors is not an exchange of favors, I'm not sure what is. And I think that this, Williams-Yulee's focus on the difference between the judicial role and the role of politicians can underscore the need to insulate judicial campaigns from other political campaigns. I mean, and it's important to remember, too, that I'm a little hopeful that maybe Article 3 judges will understand this, because the same rules apply to them. Federal judges can't go out and campaign with people. And imagine the spectacle if the Ninth Circuit split off into their various factions and went out and started stumping for presidential candidates. I mean, the damage to the reputation of the judiciary would be unbelievable. And I think it's also important to remember, Justice Roberts, I think, understood in Williams-Yulee that the infringement on the First Amendment was incredibly minor. The only thing the personal solicitation canon forbids is, "and please give me money." And that message can come from your campaign committee anyway. There's no real infringement on the First Amendment rights. What I'm not quite sure that the court appreciates is and certainly Justice Kennedy does not appreciate, is that the First Amendment is not the only interest in play. The Fifth Amendment and the guarantee of due process are absolutely protected by these rules. And I think it's also important to remember we restrict the speech of judges and lawyers in all manner of ways. Nobody has brought a challenge saying that when they're running for judge, the First Amendment infringes on their rights because they can no longer have ex parte communications or divulge the confidential information of their clients. You know, these are all ways in which the legal profession and the judiciary restrict what you can and can't say. And I think just because the fact that sometimes these restrictions also apply in the context of campaigns is no reason to throw the baby out with the bathwater.
So Suzanne, besides the issue of personal solicitation in Wolfson, is there anything else that you see in Williams-Yulee that helps on the case?
Well, I am hopeful that the recognition of the state's compelling interest in a fair judiciary that was definitely recognized in Williams-Yulee will be helpful in upholding at least 3 of the political activities restrictions against candidates and sitting judges. I think they should be applied equally. I really disagree with the panel's decision to apply them differently.
Now, we want to open it up to the audience for questions for our panelists. Do we have any questions? Oh, yes, put it on the note card, and they'll be collected and brought up to us. In the meantime, let me say this. For a while there, we had the issue of pledges or promises being under attack. Does Williams-Yulee give us some confidence that that canon of judicial ethics is safe?
I think we should feel better about it than we did before Williams-Yulee. I think, and all due credit to the many state bar associations and the ABA that have worked diligently to amend canons rather than allow them to go all the way up to a Supreme Court that is not necessarily sympathetic to these issues. At the Brennan Center, we work on all manner of democracy issues, and a lot of what we do is playing defense. And I think with this current court, it's often better to try and resolve these issues before they reach the court. And I would not take Williams-Yulee necessarily as an invitation to run all of our issues up the flagpole and see what happens.
And that's true. It brings to mind what happens in most campaigns, whether you're talking about a true election or a retention campaign, is the polls you get from different organizations asking you how you feel, I guess it's a survey, how you feel about certain issues. We have taken, some of us anyway, have taken the position that we will not answer them. That these organizations are really trying to have something to say about your position on various issues, political issues. And so we take the position that we don't answer them. You get them all the time from Americans for Prosperity, even a friendly group. We won't answer them. The League of Women Voters will send them out, different organizations. And it just seems to me that the less that judicial candidates say, the better. And when you start answering those kinds of surveys, you really, I think, putting yourself at risk, because the next thing you will see, the next newspaper article you will see, will be about your answers to those particular questions, and then they will say that you are, making political decisions. And so I hate this whole notion of pledges and promises and how you feel on certain issues. I can't feel about certain issues until the issue comes and I see what statute I'm working with and what constitutional provision is applicable to it.
Right, well, some of the questions from the audience. What are the best strategies for getting more Article III judges to understand and appreciate what their state colleagues are going through in these elections?
That's a good question. You know, it just seems to me that because they don't have to do it, that it's hard for them to understand. I have just really come to the notion that election of judges is just a terrible thing. I must tell you that I watched my own, and I have paid very close attention to actual elections, you know, from the trial court level. And no matter what you do, it puts judges and people who are helping them and the lawyers who are the more likely people to give money, it puts everyone in just a very awkward position. And I don't know how you can explain that to some people who don't ever have to go through it. Justice Roberts seems to have understood it, and maybe if we keep at it, but you know, I don't want to have to keep at it, because the more you bring cases, you have to bring these issues before them, the likelihood is we're going to get something we don't like. So my answer is I don't know.
And I think in the context of the Williams-Yulee case, among the amicus briefs, we had the Conference of Chief Justices weighed in, and then we had a brief by several retired Supreme Court justices, two of whom will be your keynote speakers here. And I think having those voices weigh in when these issues come up, and speaking from personal experience, while the Article III judges may not have the direct experience, I think they have a respect for fellow jurists, and hearing from their fellow jurists who came to office via election was indispensable in the Williams-Yulee case.
Matt, I'm curious, do you think that Justice Sotomayor's question had an impact on her colleagues?
I think it might. It started a line of 3 or 4 questions on the court where they followed up with this idea that it seems very unrealistic that a judge asking a lawyer for something is not different in kind from anybody else asking a lawyer for something.
Right.
I know, I'm sorry, just a comment. I know in Arizona, we recently had a judge, at least in southern Arizona, who had been in a county who had faced, you know, had been through this election process. So at least having, like you said, other judges who have gone through that process, I think that their voices are important.
Now, one question that several people have asked out of Williams-Yulee is they said, well, you know, what kind of practical difference does the ban on personal solicitation have? Some of the critics of the decision said, well, you know, they can find out, as Peggy acknowledged, after the fact. They can send thank you notes later. So the impact of possible bias really may still be there. So let's start with you, Suzanne.
I agree, and I would actually, and to some extent, that the fact that they can see the list of who has contributed, you know, can also create this bias. You know, they've seen that I've contributed or I've not contributed, but it's still different than that direct ask. It's, you know, as they referred to the Girl Scouts, and I'm on the board of Southern Arizona Girl Scouts, so please buy those Girl Scout cookies. But it is different when someone is asking you for something directly and personally, or even on a telephone call. That was something that Wolfson wanted to do, was be able to make telephone calls to solicit campaigns. So there is that difference. And rather than going towards allowing for personal solicitations, I would rather go towards the not allowing those judges to see the list of who has contributed to those campaigns for that reason.
Not allowing, I'm sorry.
Not allowing the judicial candidates or judges to see the list of who contributed.
Yeah, well, I think practically this decision kept the perfect from being the enemy of the good. It may be better to further insulate judges from this process, but I think Justice Roberts identified this in his opinion, that this is ultimately an argument about under-inclusiveness, and not to get into legal jargon, but the argument is essentially that there's a problem with the law because it prohibits too little. And I think leaving the door open for additional steps to tighten these rules, again, while 39 states still insist on using elections, I think we should do everything we can to protect the judiciary in that states while taking steps to try and convince them to move to systems that, you know, aren't characterized by these pressures.
And I think there's a world of difference in not seeing a name on a list from looking someone in the eye and them telling you no, they're not going to give you a contribution. I mean, there's a world of difference in that. And someone's name not being on the list doesn't necessarily mean they didn't do anything. They could have talked to their neighbors and friends and encouraged them to go out and vote. In my retention, I know a friend of mine went out, had some T-shirts made, and would go to picnics and things like that. And she didn't have a lot of money to contribute to the campaign, but she did what she could do. And so I don't think that a name missing from a list is the same as me looking you in the face and you saying, no, or I can't do it, or whatever it is you might do. And especially in contested elections, real elections, I may decide I want to back candidate X, but candidate Y comes to me and wants a contribution. Now that's a really awkward situation to be in when you know that you prefer the other candidate. And so I think there's a real difference here that can't be underscored.
Now, several in our audience wonder whether anything that was said in Williams-Yulee can be translated into the likely next battles over campaign finance reform not affecting the judiciary. So Matt, why don't you start with whether there's anything there that might change the direction of that jurisprudence?
I think this is ultimately maybe the most interesting question coming out of Williams-Yulee. My personal answer is no in the short term, and maybe, hopefully, in the long term. The majority was very focused on distinguishing judges from politicians, and the very nature of this opinion is we have to treat judicial elections, or we can treat judicial elections differently than other elections. And in the majority, Justice Roberts, again, referencing the McCutcheon case, emphasized the conservative view that the electoral responsiveness of politicians to their supporters is somehow at the heart of the democratic process. Now, that said, if you think about it, there's nothing about the rationale of impartial judges that shouldn't apply to politics in general. You know, our politicians don't only represent their campaign contributors, they represent their constituents. And I think, you know, one of the things that we are doing at the Brennan Center is we have a long-term project to try and reshape jurisprudential thought on campaign finance reform. And I think it's not crazy that if we see a changed composition of the court, you might see a lot of references to the majority opinion in Williams-Yulee in a campaign finance decision that might roll back Citizens United or McCutcheon. I just strongly encourage all of you not to hold your breath right now for that to happen.
Well, I guess I am hopeful that there could be at least some tweaking of Citizens United when it comes to judicial campaigns, because really that's what we saw in the retention is not so much individual donors, but the fact that a PAC can get together and just start the opposition. And that's what becomes the real danger in these elections.
So a follow-up question that was related from the audience is that is this part of the explanation of Kennedy's dissent that he was worried about laying down some markers that might undermine Citizens United?
That, if anybody can explain Kennedy's dissent to me, I'd be interested to hear. I don't know if any of you have read it. It reads like he is talking about a different case. He uses language like censorship and tyranny, and the cure for speech is more speech. We're talking about judges not being able to say, and please give me money, which message can still go through anyway. And I think what it shows is that could be part of his concern. I think also I've read a lot of legal theorists talking about how do you explain him. Is he the ultimate swing vote moderate? I think no. I think he has very strong views on an idiosyncratic set of issues. And when it comes to the First Amendment, I don't think he recognizes that there is any other interest in play besides the First Amendment.
Right. One question was directed directly to you, Peggy, but I do want the others to weigh in. And this is a practical question. Okay. You know, what were the steps that you feel made the biggest difference on the retention election that you went through in 2012?
I think there were several things. We actually started out with a consultant who did some polling and tried to figure out what the public understood about retention elections. We had a group in Florida, I'm now having one of my senior moments, Democracy at Stake, that really came out and helped to deal with public education about retention elections. We also had the bar. The bar did a brochure called The Vote is in Your Court. And that brochure explained retention elections and what the intent of retention elections was. And the bar, of course, every year does profiles of everyone who is up for retention, whether it's an appellate court judge or a Supreme Court justice. So it really was all of these forces coming together to help us, because the three of us, although I feel like I traveled from one end of the state of Florida to the other, multiple times, we just could not reach everyone. And so even individual bar members would go out and help educate the public about retentions. And so I can't forget our Committee of Responsible Persons, who were the ones who actually raised the over $1 million that we had, because we went out and went to the social media, just like the opposition was doing. We had our individual profiles that we did and that were shown on YouTube and whatever. I don't use any of the social media personally, but we did during that campaign. And so it was all of these factors really coming together that I think made a significant difference.
Suzanne, do you have any observations about what works for judges?
I was thinking that education would be the key, but there's one kind of nuance that we have in Arizona. For those counties where we do have merit selection, we do have retention elections of those judges, those trial court judges, and we have a judicial performance review committee. And so when someone appears in front of a judge, they have an opportunity to fill out a survey on, and I don't recall exactly what all is, the categories are on that survey. And then those are collected and all that data is discussed amongst these the committee members, and then they give a recommendation on whether the judge should be retained or shouldn't. And it's, as you can imagine, because we have such great judges, it's very rare that they don't recommend it. So I would think the education of the committee's opinion would also be important to get that out there.
Now, one of our audience suggests that the decision will translate differently at the state level, where in some states it'll have more leverage, in other states it'll have less. Do you think that this is true? That states will look at this differently, will react to it differently, and that rather than see some uniformity among the states, we're going to see different approaches?
Probably. I mean, laboratories of democracy and all that. Generally, if you give any issue to 39 states, it's going to be interpreted differently in some than in others. And, I think part of it depends on us, the people here in the room and our allies in the states, and how effective we can be in advocacy efforts to improve the conduct of elections where elections are still used. So, part of that rests on us.
And I think a part of it may be what has been their judicial history. I mean, in a state like ours, where we had such a terrible history, we were pretty adamant about this particular canon. And so if you've never had that kind of experience, you may not see this as what I consider to be one of the fundamental things that candidates for judicial office should be concerned with.
Yeah, I was kind of, not knowing how all the other states approach, those that use elections, how they do it. If they don't already have restrictions on personal solicitations, and I would expect that they would implement them, or at least hope.
And Peggy, you said a lot depends on your experience, and the experience informs the way you look at these issues. I think that's one reason why I agree with Matt that Justice Sotomayor's question had an outsized impact on her colleagues. David Souter, during his first year on the Supreme Court, likes to tell a story because he overlapped just that 1 year with Thurgood Marshall. And he likes to say that, as a junior justice, you have to take down the notes about who voted what way in conference, and that sort of thing. And very early in his tenure there, Marshall sort of grunted something in response to a decision in a bankruptcy case. And Souter was not clear whether that meant he was for the petitioner or the respondent. So he went to Marshall's chambers afterwards. And Marshall said, "Sit down, if you knew anything about me, you'd know that I was for the petitioner in this case." And he goes, "So let me tell you a story." And he started telling him stories from his barnstorming days as a civil rights lawyer, and what really happened, and why that makes a difference in the way that he looks at things. And Souter says that he knew about those things at an intellectual level. He knew about the precedents that Marshall helped create. But that type of actual understanding of what he went through personally, what he saw, why he thought these were sufficient problems, and what the real problems the real people were facing, he said had a bigger impact on him than any of the oral arguments. And so I think when judges bring those experiences to the deliberations, it does make a difference. Things look different than when you know them only at an intellectual level. So given the fact that we have judges in 39 states to some extent going through elections, we have these issues coming up frequently in federal courts where, for the most part, certainly on the Supreme Court, we have no former state court judges on the court at the moment. We have no one who's ever had to run in any kind of election. Is it just the amicus briefs that can bring forth this kind of thing, or is there another way that that court and other Article III judges can get a better sense?
I mean, again, I think, we need efforts by the bar, we need efforts by the ABA and state bar organizations. I think we need efforts by the judges and, those of us who are concerned about these issues to try and build those bridges. I think it's hard. Life tenure is supposed to give you the ability to be completely independent, and in some ways it gives you the ability to not have an obligation to take steps to understand the experiences of your colleagues who may face elections.
In Arizona, do state and federal judges have conferences together?
They do have judicial conference there because it is a small bar and a small judiciary. They often have practiced together. They have been lawyers together before they were judges, and there's definitely a tight collegiality between federal and state judges.
And Peggy, how often are you at conferences or other kinds of meetings where there's interaction with federal judges?
It's not very often. Actually, as a lawyer, I probably interacted more with federal judges than I do now as a state court judge. We go to the Florida bar meetings, for example, together, and but not a lot of the federal judges come. Some do, but not a lot of them. And I will see some occasionally at American Bar Association meetings. But I think there really ought to be more interaction between federal judges and state court judges. Just, I think we ought to have some kind of conference where we get together So we understand the kinds of things that each are going through. And I think there really is a lack of understanding by federal court judges of the dynamics and the pressures that state court judges face.
I certainly have experienced that in the Wisconsin litigation where we are in federal court and the judge who is presiding, who's been on the bench about a year, had no clue. He said, I need information about what the Chief Justice of the Wisconsin Supreme Court's responsibilities are. It was that general a question. So it's clear that there is an educational effort to go through. So we've got just a couple minutes left. Any last thoughts that we have not covered that you want to convey to our audience?
I wanted to add, the panel, the three-member panel that originally decided the Wolfson case had refused or declined to address whether the hypotheticals that they referred to as situations where you had one judge in a county. We have 4 counties in Arizona that only have one judge. So recusal, although it is important and is not used as much as I believe it should be, that's an issue. If in a county where it only has one judge, you're going to have some judge come from another county or have an attorney sit as the judge in that case. And then they also declined to address situations such as litigants that appear frequently, so, as maybe a county sheriff. So I just wanted to mention that. Recusal is not really a good alternative.
Matt?
While the theme of this panel has been to celebrate a major win, in my role as the chair of the Fair Courts Litigation Task Force, I would like to offer a note of caution. While we seem to have successfully preserved the personal solicitation canon, and we should be very proud of that, the way in which the Chief Justice crafted his opinion purporting to apply strict scrutiny certainly will not make it easier to defend the other canons, and I expect that the other side watch for Jim Bopp to start using that language in every case that he brings now. And I want to point out, I know this will be addressed by other panels as well, but in addition to the canons litigation, in terms of threats to the integrity of our judiciary, we should all be watching Kansas, and we should all be very concerned. And talk to Ryan and Callie sometime today or tomorrow, but we are currently litigating a challenge where they passed a law that threatens to completely defund the entire state judiciary. And last week there was an article by Eric Erickson, who is a unfortunately influential figure on the right, who it was essentially a cry to core asking why legislators all over the country aren't shutting courthouse doors, aren't forcing judges to fire their clerks, aren't trying to cut their salaries and turning off the lights. And I am concerned that this might become a template, particularly in the states where the state government has moved rapidly to the right while the Supreme Court has stayed essentially where they were.
Last word, Peggy.
All right. I think that we need to be ever vigilant and have people talk to our legislators. In our state, some of the biggest threats come to possible proposed constitutional amendments about the judiciary that the legislature can put on the ballot. We've seen them talk about splitting our court into the civil criminal kind of situation. We've seen them talk about putting constitutional amendments on the ballot that we would need 60% for retention instead of a simple majority. By the way, they wanted to put what they consider the 3 most liberal judges on the criminal court. They want to keep us away from all the civil litigation. And other items like that. There's always a threat to our funding in a state where the judicial branch only gets 0.7% of the entire state budget. 0.7%, not 7%. Less than 1% of the state budget goes to the judiciary. There's always talks of even reducing that. And so I think we need to have more people who truly believe in the third branch of government acting on that branch's behalf with the legislatures.
So please join me in thanking our panelists for getting the summer off to a terrific start. And thank you all.
All right.
Well done. Thank you, Bob. Thank you to an excellent panel. We're off to a great start. Let me just put in a little bit more of a plug for something you heard about. The Fair Courts Litigation Task Force, there's a flyer in your folder about this. This group's been around now for several years. They've been doing terrific work on a lot of the cases discussed today, on a lot of other cases that involve the fair courts world. This is something that did not exist before, and it's making a huge difference. And within that set of thank yous, let me add a special thank you and ask you to join me. Matt Menendez essentially was our all-star quarterback of the amicus team here for Williams-Yulee. This victory is huge, and that amicus strategy was one that Matt really drove for everyone. So please give a grateful and raucous round of applause for Matt's work here.